The knock that changes everything. It usually does not happen in the middle of chaos. It happens in ordinary moments: a Sunday dinner, early morning coffee, kids are still asleep in the next room, and then 3 hard knocks that feel louder than they should, not polite, not casual, commanding, urgent, designed to make you react before you think. Most people believe danger looks dramatic: raised voices, flashing lights, obvious threats. But legal danger often arrives quietly, wearing uniforms, using official language, and asking simple questions through a closed door. The real risk is not always what they say, it is what you do next. Defense attorneys who handle these cases repeat the same pattern over and over. The mistake does not happen in court, it happens at the threshold. The moment the door opens, the moment a foot crosses the frame, the moment a person steps outside just to talk. By the time lawyers are involved, the critical error is already locked into the police report. Today, we are not talking about confrontation or hostility. We are talking about one mistake that turns manageable encounters into life-altering ones. A mistake rooted in politeness, fear, and misunderstanding of how the law treats a front door. Because in legal reality, that door is not just wood and hinges. It is a boundary. And what happens at that boundary decides more cases than most people will ever realize. Section 1. Door is a legal line, not a social gesture. The first mistake begins with manners. Society teaches openness. Someone knocks, you answer. When someone calls your name, you respond. Politeness is rewarded in daily life, but the legal system does not measure politeness. It measures consent, visibility, and access. Courts treat the doorway as a constitutional threshold. Inside the home, protections are at their strongest. Outside the home, those protections narrow rapidly. When the door opens, even slightly, the legal environment changes. Visibility increases. Officers gain angles. Statements become voluntary. What feels like courtesy becomes legal permission. Many people do not realize that the law does not require them to open the door to speak. Communication can occur through a closed barrier. Windows, cameras, intercoms, or silence itself are all legally acceptable responses. The mistake is believing that silence appears guilty. In court, silence is neutrality. Opening the door is action. Attorneys often describe this moment as the quietest turning point in a case. No shouting, no threats, just a hinge moving. And once it moves, the legal analysis shifts from protected space to exposed interaction. Key takeaways: a closed door maintains maximum legal protection. Opening the door increases visibility and exposure. Politeness is not a legal obligation. Silence does not equal guilt. Section 2. Stepping outside shrinks your legal shield. The second mistake happens a few seconds later. Officers frequently request a simple step outside. The language is casual. Can you come talk for a moment? It sounds harmless, even respectful. But legally, stepping outside transforms the encounter more than almost any other action. Inside the home, officers face strict limits. Outside, the standards loosen. Detention becomes easier to justify. Identification requests become routine. The protective weight of the home disappears the moment a person crosses that threshold voluntarily. Courts repeatedly emphasize location, not emotion, not tone. Location. The difference between standing inside a doorway and standing on a porch can determine which constitutional standards apply. Many defendants later learned that the conversation itself was not the issue. The location of the conversation was. Defense lawyers see this pattern constantly. A person steps outside to be cooperative, and within minutes the interaction expands. Questions multiply. Movements are restricted. What began as voluntary presence became investigatory control, and the individual does not always realize when that shift occurred. Key takeaways: location determines legal protection strength. Voluntary exit reduces constitutional safeguards. Cooperation does not require stepping outside. Porch conversations often become detentions. Section 3. The warrant confusion that opens doors. The third mistake grows from misunderstanding paperwork. The word warrant carries authority. It triggers immediate compliance in most people, but not all warrants carry equal power. Courts distinguish sharply between judicial warrants signed by judges and administrative documents signed by agency officials. Only a judge-signed warrant typically authorizes forced entry into a residence. Administrative paperwork often does not. The confusion arises because both documents look official, both contain seals, both use legal language, and most people do not pause long enough to inspect signatures or issuing authorities. Prosecutors know that voluntary entry is easier than forced entry. Voluntary entry bypasses many legal challenges. Once consent is given, arguments about document validity become harder to win. That is why officers often request cooperation first and rely on authority second. The legal lesson here is not defiance, it is verification. calmly requesting to view a judge-signed warrant through a window or camera maintains composure while preserving rights. The mistake is assuming every piece of paper demands immediate compliance. Key takeaways: not all warrants authorize entry. Judicial signatures carry different authority. Voluntary consent overrides document disputes. Verification is lawful and non-confrontational. Section 4. Tactics that sound helpful but create access. The fourth mistake is emotional. Officers may use language that feels reassuring or urgent, returning lost property, asking for witness assistance, mentioning nearby emergencies. These approaches appeal to empathy and civic duty. Most people respond because they want to be helpful, not because they feel threatened. Courts recognize that consent obtained through calm persuasion is still consent. The tone of the request does not weaken its legal effect. Once a door opens in response to a seemingly benign reason, visibility expands and authority follows. Defense attorneys often describe these moments as soft entries. No force, no raised voices, just cooperation triggered by goodwill. Yet legally, the outcome is identical to more forceful methods. Access is access, regardless of how politely it was achieved. The danger is not kindness. The danger is forgetting that legal rights operate independently of emotional instincts. A helpful response can unintentionally remove the very protections the individual intended to preserve. Key takeaways: helpful language can still create legal consent. Emotional reactions override legal caution. Soft tactics carry hard legal consequences. Rights remain intact only when boundaries stay closed. Section 5. The moment force feels justified but backfires. The fifth mistake is reactive force. When a door is blocked or a foot appears in the frame, instinct pushes toward physical resistance. Shoving the door, kicking the obstruction, using strength to reclaim space. From a human standpoint, it feels protective. From a legal standpoint, it often produces immediate criminal exposure. Courts rarely evaluate these actions sympathetically. Even if entry was questionable, physical contact with officers frequently leads to additional charges that overshadow the original issue. Defense strategies weaken when resistance enters the record. Experienced attorneys emphasize a difficult truth. Legal battles are won later, not at the threshold. Physical confrontation creates immediate consequences that cannot easily be undone. Verbal refusal preserves objections. Physical force multiplies problems. The strongest legal posture in these moments is visible calm. Hands open, words are clear, no contact. The law records behavior as much as legality, and calm behavior strengthens later arguments far more than physical resistance ever could. Key takeaways: physical resistance escalates charges instantly. Courts penalize contact more than confusion. Verbal refusal preserves legal leverage. Calm behavior strengthens future defense. Section 6. The words that give away control. The sixth mistake is not physical, it is verbal. People assume that if they have done nothing wrong, explanation will clear everything up. They start talking to fill the silence. They answer questions casually. They try to sound cooperative, reasonable, helpful, and in doing so, they surrender control of the encounter. Courts do not evaluate conversations by intention. They evaluate them by content. A single volunteered sentence can establish identity, location history, associations, or timelines that later become evidentiary anchors. Officers are trained to ask simple, open-ended questions, precisely because they invite oversharing. Silence, on the other hand, is legally neutral. It cannot be twisted, reinterpreted, or misquoted. Attorneys often describe silence as the cleanest record a person can create. It leaves no ambiguity, no contradictions, no unnecessary details for prosecutors to analyze months later. The mistake is believing conversation equals safety. In reality, conversation equals exposure. The law does not reward explanations in tense moments. It rewards restraint. The strongest position is calm refusal to answer, not argumentative refusal. Simply a clear invocation of the right to remain silent and nothing more. Key takeaways: words create evidence even when intentions are harmless. Oversharing weakens later defenses. Silence is legally neutral and powerful. Calm verbal restraint preserves control. Section 7. The paper that ends fight before it starts. The seventh mistake arrives with a clipboard. Documents appear routine. Sign here, initial there. It sounds procedural, administrative, and harmless. But courts treat signed paperwork as deliberate consent, and consent on paper is extraordinarily difficult to undo. Most people sign because they want the encounter to end quickly. They believe cooperation will speed resolution. Defense lawyers consistently warn that signatures often do the opposite. A rushed signature can waive rights, confirm statements, or acknowledge conditions the signer never fully understood. Judges rarely accept "I didn't read it" as a defense. The legal system assumes that signing equals agreement. The emotional pressure of the moment does not erase that assumption later. This is why experienced attorneys advise one universal rule: no signatures without counsel, or at minimum, full comprehension and calm evaluation. The danger is not paperwork itself. The danger is haste. A document signed under stress becomes permanent, while silence remains reversible. In legal disputes, the pen often outweighs the voice. Key takeaways: signatures carry long-term legal weight. Rushed paperwork closes future arguments. Courts assume understanding once signed. Delay is safer than regret. Section 8. The illusion of quick cooperation. The eighth mistake is optimism. Many people believe brief cooperation will shorten the encounter. A quick answer, a short conversation, a small gesture of compliance. The hope is that politeness will signal harmlessness and allow everyone to move on. In practice, limited cooperation often expands the interaction instead of shrinking it. Once dialogue begins, additional questions follow naturally. Once a small request is granted, larger ones appear reasonable. The boundary erodes gradually, not dramatically, which is why it feels harmless while it is happening. Attorneys often compare this to opening a gate an inch and expecting the outside world to remain still. Legally, partial consent becomes full access more often than people expect. Courts view each cooperative step as voluntary, even if the person felt subtle pressure. The safer strategy is consistency, either full silence with clear rights invocation or deliberate, informed communication through counsel. Half measures create ambiguity, and ambiguity rarely favors defendants. Key takeaways: small cooperation invites larger requests. Partial consent is still consent in court. Optimism weakens boundaries. Consistency protects legal clarity. Section 9. The camera that becomes a witness. The ninth mistake is forgetting documentation. Intense encounters, memory becomes unreliable. Stress alters perception, compresses timelines, and distorts detail. What felt clear in the moment becomes fragmented later. This is where recording devices transform from convenience into legal tools. Courts treat video and audio as neutral observers. They capture tone, timing, positioning, and language without emotional bias. A recording can confirm calm behavior, clarify disputed statements, and prevent mischaracterization months later. Without documentation, the case often becomes a contest of recollections rather than facts. Defense attorneys frequently note that recordings do not need to be confrontational. Quiet documentation is enough. Visible phones or door cameras serve as silent witnesses, discouraging escalation and preserving an accurate record simultaneously. The mistake is assuming memory will be sufficient. The legal system values verifiable evidence over personal recollection every time. Technology, when used calmly, becomes a safeguard rather than a provocation. Key takeaways: memory fades, recordings endure. Documentation preserves tone and sequence. Quiet recording discourages escalation. Evidence strengthens later defenses. Section 10. Preparation turns panic into procedure. The 10th mistake happens long before any knock. Unprepared households rely on instinct. Prepared households rely on routine. The difference is not intelligence or courage. It is a rehearsal. Knowing which words to use, whom to call, and how to respond removes uncertainty from moments designed to create confusion. Preparation is not paranoia. It is procedural awareness. Families that discuss responses, keep contact numbers accessible, and agree on silence protocols experience fewer irreversible mistakes. Courts move quickly, and the first few minutes of any encounter often shape everything that follows. Legal professionals emphasize that preparation creates predictability. Predictability produces calm. Calm produces clean records. The absence of preparation produces hesitation, and hesitation invites errors that cannot be undone later. The law does not expect perfection, but it assumes responsibility. Those who plan ahead retain agency. Those who rely on improvisation often surrender it without realizing when it happened. Key takeaways: preparation reduces panic-driven mistakes. Early minutes determine long-term outcomes. Family coordination protects everyone involved. Predictability strengthens legal positioning. The threshold decides the story. The most powerful legal moments are rarely loud. They are quiet. A hinge turning, a step forward, a signature placed without pause, a sentence spoken to fill silence. The system does not judge fear. It judges actions recorded in reports and preserved in evidence. What feels like courtesy or urgency in the moment becomes a permanent entry in a legal narrative later. And narratives, once written, are difficult to rewrite. Rights do not vanish instantly. They erode through small decisions made under pressure. A closed door maintains protection. A calm voice maintains clarity. clarity. Preparation maintains control. These are not acts of defiance, they are acts of understanding. In the end, the mistake most people make is not ignorance of the law, it is forgetting that the law measures boundaries, not intentions. And the boundary of a doorway is one of the most consequential lines a person will ever cross. Remember this, strength in these moments is quiet, control is calm, and the difference between walking freely and fighting uphill in court often begins with a single choice made at the threshold.